investors, experts, and other folks who are interested in developing commercial space companies located in Chicago. Our long-term vision is to put Chicago on the map in the space industry, particularly in the new space industry. So we're focusing really on encouraging startups and helping people build companies that are going to help us settle the solar system. So before we get started, just a couple of issues, a few items I want to address. First, if you haven't found bathrooms, the restrooms are back the way you came in. You walked by them on the way here. They're on this side of the multicolored bureau on the big hallway up there. Secondly, I'd like to give a shout out to our sponsors. MHub is the space that we have here. MHub is a center for manufacturing innovation and a startup incubator focused on helping companies that want to build products get over the large hurdles to building manufacturing type of products. If you haven't seen the space behind the wall, it's really an amazing space. And we can probably arrange for a tour if you want to see it later after the presentation. Secondly, Metropolitan Brewing provided the beer that you're drinking this evening. They are a local Chicago craft brewery and also a local startup, so we appreciate their support. So this evening, our topic is legal challenges in commercial space. And our speaker is Charles Mudd. He has been an attorney in Chicago for 16 years. His practice is primarily revolved around intellectual property and startups in the internet. And recently he has become interested in space law and has opened up his practice to the challenges, legal challenges that startups face in going to space. So without further ado, I'd like to introduce Charles.
Good evening. Well, I'd like to thank Dave Hurst for bringing me, one, into New Space Chicago, and then I attended my first New Space Chicago event in January, took a tour of MHub, and although I have my office on the north side of Chicago, we also went ahead and obtained a fixed desk or reserve desk here at MHub, because behind, sounds like Wizard of Oz, behind the curtain, behind the wall is a very cool space. Talking about space, I'm going to discuss certain aspects of space law tonight with you. What I'm going to try to do is give an overview, dive deep into some particular nuances of probably, I would say, one of the more important areas of understanding space law for startups, and then circle back to the end. I do want to thank New Space Chicago, MHub, and Dave Hurst again. So basically, this presentation is going to start off talking about space law, what I think space law to be, discussing the regulatory regimes, going into ITAR and EAR or export administration regulations, and then finally talking about somewhat of the vision for the future, both in a legal perspective and more of a commerce as well, commercial space. Beginning with space law, you know, when I talk to people about space law, a lot of times the nuances are, all right, well, we think that it's law specifically targeted to the commercial space industry or something related to going into outer space. And certainly there are those up at the top of the pyramid. Yet space law, the broad sense of space law, encompasses a lot more. You have your traditional law, so that any startup business is going to have to face aspects of employment law, contracts, non-compete agreements, and so forth. That kind of leads into the intellectual property. Again, an aspect of traditional law, but I broke it out separately because there are four main areas of intellectual property: trade secrets, copyright,
patents and trademarks. And all but one of those are public. So when you file a copyright, when you file a trademark or a patent, unless there are specific circumstances, there's going to be a public filing. Trade secrets are, as the name implies, a secret. Regulatory regime with respect to the commercial space industry is there's not just, as in the United States, there's not just one agency. For example, in privacy law, if you go to Europe, there's one overarching privacy law. Very easy, very straightforward. We may not like it here in the US, but it's going to be the GDPR in May, goes into effect. Here in the United States, it's a wild hodgepodge of different statutes, and then you've got state statutes and so forth. That's very similar to almost any industry, including space, commercial space industry. And finally, nuance law is a subset of the regulatory regime that kind of does have more of a specific aspect to certain industries. And then finally, space-specific law is your domestic and international law that is really targeting what happens outside of the terrestrial area, such as the Outer Space Treaty, recent legislation, both the United States or in the United States about mining asteroids and so forth, that has specific aspects to space. Gone through that. So I'm going to focus tonight, and hopefully you'll survive the morass of regulatory aspects, but we're going to talk generally about the regulatory regime, and then I'm going to dive into ITAR and EAR. Those are, as I said, the two most important aspects, I think, of laws related to the commercial space industry because of what happens if you don't know about them. So let's talk about the regulatory regime. Talk about some of the agencies and some of the laws that apply. You have the Department of Transportation with the FAA. FAA is an agency within the Department of Transportation. You have the Commercial Space Launch Act that is enforced through the FAA. FCC, satellites and communications regulate that kind of aspect. Department of Commerce, NOAA. Actually, yes, the National Oceanic and Atmospheric Administration regulates remote sensing technologies, among other things. The State Department involves ITAR, or regulates ITAR, and then the Department of Defense also has certain branches, such as the Air Force, that monitors orbits of objects beyond a certain size. So this is just an example of the varying statutes and regulations that could apply to a business depending on what their nuances is, what their activities happen to be within the commercial space industry. The future of space law, a little bit this here are, legislation dealing with, what language that is?
Fake Latin.
Fake Latin. Manned missions, because we really don't have the regulation, that there's not really much to say about it in terms of specific legislation because it's not there yet. But it's a particular important area because any kind of regulatory aspects relating to manned missions going up is going up into space on a commercial aspect is going to have to be developed, and it hasn't been yet. And then we also have space mining, although we did recently, I think it was 2015, if I'm not mistaken, there's been statutes that have been passed in the United States relating to mining certain extraterrestrial asteroids and so forth. But that also, some would argue that that goes up against the Outer Space Treaty, and there's a conflict there. So these are developments that are going to have to be resolved in the future. And yet more legislation is going to have to be enacted dealing with orbital traffic, the electromagnetic spectrum, and export controls, which we're going to get into with ITAR and EAR. Beyond that, we're talking just domestic law at the moment. Beyond that, we're going to have to develop a means to cooperate and enact treaties and laws that many countries will abide by. Right now, we don't necessarily have the best policy position in the United States to kind of do that, and it's kind of a, it seems that our regulatory or the decisions are on a whim these days, but that is something that's going to be having to happen, is there's going to have to be a consensus among other countries, particularly the EU and the United States, on many of these issues. So let's talk export controls. ITAR is the International Traffic in Arms Regulations. And many people, when I talk to them about ITAR, one of the questions is, why would you need to worry about trading arms if you're involved in the commercial space industry? Well, as we'll see, ITAR is very broad in what it covers, and it regulates the export and import of certain technologies that could be used for defense purposes. Likewise, and that's under the Department of State, but a parallel aspect is the Department of Commerce and its export administration regulations. Both sets of regulations attempt to do the same thing, and that is regulate the export and import of certain technologies, services. It's not just products, it's also services. So we're going to get into that, but I'm not going to be able to give any specific advice to any particular person or company tonight, other than, as I hope that you will see, you really should, if you find yourself, if you even think that you might be covered by either of those two, consult an attorney. How many attorneys are in the room? Just 3, including myself. All right. For those that aren't, and you may already know this, but at the federal level, and this is really all that I'm going to be talking about, is the federal statutes, federal laws. We have the enabling statutes, or the overarching statutes, that Congress would enact, and then the president signs. And those are your United States code. So anytime you see a citation to USC, section whatever, that's to an actual statute in the code. And then oftentimes those codes, the statutes, will require the creation and implementation of regulations through the different agencies. And that's where you have your CFR, a Code of Federal Regulations. So any citation to CFR, section whatever, is the regulations, Code of Federal Regulations. And all of the statutes and the Code of Federal Regulations are available online for your enjoyment. So I've kind of talked about what ITAR is, and what its objective is, and it's meant to regulate the export, import, sharing of items and information that happen to be found on the United States munitions list. And again, oftentimes there's the question, why should I even be worried about what's on the United States munitions list? Well, unless you've actually read the United States munitions list, you may very well ask that question, but I will show you, as we get into this, the broad range of different technologies that are encompassed within that. Why be concerned about ITAR? It's just a regulation, right? Well, violation of ITAR, depending on what parts you particularly violate, may end up with, if you're upon a conviction, be fined for each violation not more than $1 million, or in prison not more than 20 years, or both. That's for each violation, and it doesn't end there. Can you hear me okay with, I guess I can keep the microphone. Without obtaining a license, so these are some of the things that will violate ITAR. Without obtaining a license, export or attempt to export from the U.S. any defense article or technical data, or furnish an attempt to do the same thing, for which a license or written approval is required. Re-export or retransfer or attempt to do any of that, any defense article, technical data, etc. Import or attempt to import any defense article whenever license is required. To conspire to do any of that. To possess or attempt to possess any defense article with the intent to export or transfer such defense article in violation of the regulation. Now, let's make a point here though. This is not talking about that you're actually intending to sell arms to another country. It's not talking about that your intent is to convey defense technology to some stranger in a dark alley in Paris, France that you don't really know. Rather, this is just whether you have the intent to actually engage in the conduct, so to sell a defense article to somebody that shouldn't have it. If you were actually intending to sell that article to someone in a foreign country, and that is a defense article on our ITAR, that's a violation of the statute, whether or not it was going to be used for nefarious purposes. And the purpose, again, here is for the United States to control the technology that comes out or comes in and goes out of the United States. Now, the foregoing are violations if you didn't have a license. The following will be ipso facto violations. So even if you do have a license, you knowingly or willfully attempt to solicit, cause, aid, or abet, or counsel, demand, induce, procure, or permit the commission of any act prohibited by any of the statutes, regulations, and so forth. Someone ineligible or knows someone to be ineligible and helps them apply for any export control document. And you'll see what the interesting broad range of documents here that ITAR encompasses in just a moment. Order, buy, receive, use, deliver, any manner, any transaction subject to the subchapter. To engage in activities without first registering or obtaining the required license or written approval. Now this is kind of a contradiction because it's an ipso facto violation that whether or not you have a license, it's a violation of this, but it says first registering or obtain the required without the required license and complying with the registration requirements. To make it a little bit more daunting, any person who's granted a license or other approval or acts pursuant to an exemption is responsible for the acts of employees, agents, and brokers. So if you have a company and you have a license, you're responsible for any employee, any subcontractor, any independent contractor, anybody that you are engaging to work on your company's behalf, you're responsible for their conduct and making sure that they comply with ITAR. Further, you can't use any export or temporary import control document containing a false statement. This is not necessarily meaning that you intended to make a false statement, but that includes a false statement. What kind of documents? Some of the documents are pretty, you might think, okay, they're relating to perhaps defense articles or electronic export information filing, application for a temporary export or registration, but others are a bit more common. Any invoice, any delivery verification, bill of lading, purchase order, airway bill, any of those documents that contain a misrepresentation or a false statement can violate ITAR. In fact, any other document used in the regulation or control of a defense article, any other shipping document that has information related to the export of the article. So any document relating to the export or import of something that ITAR considered or is under the munitions list of the defense article could violate ITAR if there are any misrepresentations. And remember that any particular violation can result in a fine of up to $1 million, not more than $1 million, but up to $1 million, or 20 years in prison, or both. But there are also other sanctions, and those sanctions can be related to immigration, deportation, debarment, seizure of assets. On top of all that, this is an addition, depending on the provision that you violate, this is an addition to the $1 million and the 20 years prison. The Assistant Secretary of State for Political Military Affairs can also impose these civil penalties. Don't ask me where they come up with the numbers. I have no idea. If I had to guess, it's probably based on the cost of living school adjustment or something each year that it gets to that strange. The civil penalty may be in addition to or in lieu of any other liability. It doesn't stop there. The Director of Defense Trade Controls may make the payment of a civil penalty under this section. So ITAR is serious and carries serious penalties if you violate it. And there are a lot of times that will require what we call, attorneys call mens rea, which really means mental state. And there are 4 basic mental states. There's negligence, there's recklessness, there's knowledge that something happened, and then there's intent. And many of your statutes, your criminal statutes, will require intentional or knowing violations. But for example, your copyright statute, there is no mens rea requirement. If you infringe somebody's copyright, whether you know it or not, you are liable under the statute. So, to whom does ITAR apply? First, we determine whether your product or service falls within the purview, and then we'll dive deep. To do that, we kind of need to dive deep into the U.S. munitions list. Now, I've got a number of slides that I'm going to fly through, but I want to hit some of them to kind of give you a sense of the broad-based aspects of that. And this is where, the relationship between an attorney or law firm and a business in something like this has to be cooperative. It's not something that you can necessarily call your attorney up and say, here's my screenplay, register it with the United States Copyright Office, and it's all kind of done. That's easy enough to do with some questions that the attorney would ask. But here, to determine whether or not you actually do fall within ITAR, the attorney needs to help you decipher and interpret the different parts of the regulations. But you need to help the attorney understand what your actual technology is, what the products are, and what you do. And if there's any kind of omission or failure in that dialogue between counsel and the business, we can run into problems. So there are categories under the United Munitions List that might seem straightforward for being on a munitions list. Launch vehicles, guided missiles, ballistic missiles, rockets, torpedoes, bombs, and mines. The only reason I bring this one up is because to the extent that we are talking about rockets like SpaceX, or using a rocket that falls within this category, then they are subject. That is something that is on the United States Munitions List. And clearly any business that is making missiles, bombs, etc. But I'm talking more from the commercial space industry on what might be included. Launchers for rockets, apparatus and devices specially designed for the handling, control, activation, and monitoring of the articles, the foregoing articles. So if you're a startup, you're a business designing the technology that's going to help track a rocket, that falls within this category. Power plants, systems, subsystem parts, components, accessories, attachments, or associated equipment as follows. Flight control and guidance systems, specially designed for the articles enumerated above. So it's not just the big systems, it's the small parts even under ITAR. Rocket or missile nozzles and nozzle throats, and specially designed parts and components, therefore. I'm going to move beyond category 4, but you can kind of see the detail that the United States Munitions List happens to be. Launch canisters. So another category, explosive and energetic materials. Then we have ground vehicles. And the only reason I put this is ground vehicles and trailers equipped with any mission systems controlled, specially designed for rockets, space launch vehicles, missiles, drones, or other unmanned aerial vehicles capable of delivering a particular payload. Aircraft and related articles. Here, the reason I included this is because it encompasses UAS or drones, because it's aircraft, whether manned, unmanned, remotely piloted, or optionally piloted. I really don't know what optionally piloted is. You would think that it either needs a pilot or it doesn't need a pilot, but personal protective equipment, body armor, providing a protection level, a certain protection level, personal protective clothing, equipment, or face paints.
goggles, spectacles, visors, vision blocks, canopies or filters for optical sights or viewers. Then military electronics, electronic equipment and systems, underwater hardware equipment, radar systems and equipment, airborne radar that maintains the positional state of an object. And then we do get to a category of spacecraft and related articles, but I hope that you see that the point of the going through many of these is that if somebody in the commercial space industry only went down the United States munition list looking for something like spacecraft and saying, well, this must be my area of concern, you're wrong. Because if the technology that you're working on or the systems or the services that you're providing fall into any of the other categories, then you're subject to ITAR. And so it's really understanding somebody that understands ITAR very well and can pull through it, and then the company making sure that that person understands what the company does so that there's not oversight. And we do have here spacecraft, satellite space vehicles, whether designated developmental, experimental, research, or scientific, having a commercial, civil, or military end use that are specially designed to mitigate effects, nuclear detonate, autonomously detect and track moving ground, airborne, missile, or space objects other than celestial bodies, conduct signals intelligence or measurement in signals intelligence, are specially designed to be used in a constellation or formation that when operated together from a virtual satellite with the characteristics of function. So you kind of get the idea. These are anti-satellite or anti-spacecraft, which has a kind of more of a defense perspective. Has space-to-ground weapon systems, have any of the following electro-optical remotes, and you can get into this and really read it, it's fun. Provide positioning, navigation, and timing signals, autonomously perform collision avoidance, so it's collision avoidance systems, ground control systems. This is kind of mimicking some of the other parts, that it's ground control systems that are designed for the spacecraft, but telemetry, tracking and control spacecraft of paragraph A, spacecraft parts, components, accessories, attachments, as follows: antenna systems designed for a particular spacecraft, spacecraft optics, space qualified focal plane arrays. How many know what that is? I'm not surprised, but space-based systems and specially designed parts and components, etc. So ITAR really, there's a lot to ITAR. The most important aspect of that is to understand, one, what the technology is. Obviously the business, the startup, the entity that's involved, or the entrepreneur is going to have an understanding of what they're doing and the components. But it's also understanding whether those components fall into these categories. Now, one clarification though, remember what the purpose of ITAR happens to be, and that's to control the export and the import of certain technologies. And so if you're not exporting the technologies and you're not importing certain technologies, you may not be subject to ITAR, but then also you need to look at your employees. If you're employing somebody from a particular country that's not a United States citizen, or if you're on a particular visa and so forth, if you're sharing that technology with them, then you are arguably exporting that information, even here if it's in the US. So that's oftentimes where there is an issue. But the next steps, once one determines that ITAR would apply, would be to register, determine whether there are exemptions that might apply, and then apply for a license. And I'm not going to get into all the nuances and aspects of that right now, because that, as I say, could be for another day. But I do want to go back to look at the similar aspects of the export administration regulations. And these are
very similar to ITAR, but different. And there's an important note to make here, and that is that they're not mutually exclusive. So you could be subject to ITAR, and depending on the circumstances, you could also be subject to IR. Does IR apply to me? There are preliminary considerations, and again, this is the Code of Federal Regulations, and there's actually a nice flowchart that provides some guidance and aspect to go through. The first question is if you're dealing with proliferation of biological or nuclear weapons or nuclear explosive devices or missiles, and we're probably not talking about that in the commercial space industry. So if the answer to that is no, then we go to exclusive jurisdiction of another agency. So the yes here means that you are subject to IR if you are doing any of those, right? Then these, if what you're doing is subject to the exclusive jurisdiction of another agency, then no. Pre-recorded records, books and pamphlets, that's kind of going to the United States Copyright Office. And so if that's what you're talking about, then you're not necessarily subject to IR. If the information is publicly available, it's not subject to IR, and you don't have to worry about that. If the foregoing questions haven't answered, if you're still going down the flow chart, then the next questions are whether or not the technology is in the US, then you are subject to IR. If the technology that you're dealing with is outside the United States, but it happens to be of US origin, you are subject to IR. Or there's a foreign-made product that has something more, it's more than de minimis use of US parts, and that's basically if the US parts exceed 10% of the value of the item, then you're subject to IR. If the US parts are less than 10% of the value of the foreign-made item, then it's not. That's generally speaking. Foreign-made with the direct result of US-made technology in specific destinations, you are subject to IR. So, in looking at the ITAR regulations, it's going through and kind of identifying some of the categories of different services, products, and so forth. They have it a little bit coded a little bit better in IR. And I'm going to go through just so that for your guidance, kind of explain a little bit about what the coding system happens to be. So each number, so you go to the ECCN list or the commercial control list of the ECCN. So every kind of technology and so forth that's subject to IR or under that has an ECCN number. And that would be similar to the OB521. The first digit on the left are the categories. And there are 10 categories. I'm not going to read through them here, but there are 10 categories numbered 0 through 9. Aerospace and propulsion is 9, navigation and avionics. Lasers and sensors might be some of the more relevant to the commercial space industry. Electronics and computers, telecom, information security may as well. The second there are groups within each of the categories, but it's the same groups for every category. And those are equipment, assemblies and components, materials, software, technology, test, and inspection and production equipment. So for every category, the 0 through 9, you're going to have then a group, and it's going to be one of those 5 groups. And then the X, where the 5, where the number is, the placement of that is the type of controls associated with the items. And those vary: national security, missile technology, nuclear proliferation. And the next digit, the Y, or the 2 in this example, would be the same one of those. If it's just 1, then it'll be a double digit. If it's more than 1, the one to the left will be the most important. So if you had national security and both missile technology, they're ordered in hierarchy of importance or severity. And so you would have the 0, where the 5 is, it would be 0 and then 1. And then the last number is just sequential numbering. So that's identifying an ECCN. And then if your technology falls within the EARLIT or the list of the ECCN numbers or has an ECCN numbers, then the next question is to determine whether certain prohibitions apply. And if any of these prohibitions apply, then you must apply for the license. Denial order, embargo destination, violate the license, have knowledge of a violation. If ECCN and no prohibitions apply, then the next question that you'd ask yourself is whether or not there's an X in the Commerce country chart. So unlike, so for EAR, they actually have a chart that lists many countries in different categories, and they'll identify whether or not that particular category for that country is subject to EAR, or you need a license for it. If no, then no license is required, but you still need to complete the EEI, the Electronic Export Information Form. If yes, then you'd ask yourself, does a license exemption apply? But here's an example of the Commerce country chart. So for Afghanistan, you nearly have it marked all the way across. And so for those different categories and certain technologies, you would not be able to export that technology to those particular countries. Now, when Dave and I were first talking about this presentation and what it might cover, I wanted to give an overview of space law, and then I really do think that ITAR and EAR are two of the most significant aspects, because I think that they're the regulations that many people don't know about, or if they do know about, they don't understand. And I've talked to many people that are involved in the commercial industry that know of ITAR and think that they understand, but hate it because it's a morass of regulations. And so I think that it's very important, given the penalties and the severity, to understand or at least have knowledge of ITAR and then the Export Administration regulations. And if you come away with anything, it's that if you are involved in this, if you think that you might have technologies in a business that would be subject to ITAR or EAR, I highly recommend that you explore that or talk to somebody that might know about it, because the penalties are severe, and it's not just whether you or the CEO, as we were talking about, has that knowledge or does something. You're responsible for all your employees. Beyond that, you're also responsible for your contractors, the people that you work with, your partners. This essentially means that you should understand the nuances of any company with whom you interact. If you are in this space and you're interacting with a company that you're getting technology from, or using technology from, or selling technology to, and you believe that they're subject to ITAR or EAR, you need to talk with them. Do they have a license? More importantly, too, you need to know your customers, and you need to know who you're selling to, because that is one of the, that's basically, here's making sure that these regulations are making sure that we're not sharing, or you're not sharing technology or selling technology to the wrong people. And so you're responsible if you're selling something to a customer that that would violate EAR, then you're gonna be in trouble. So it means that you should understand the nuances of any customer to whom you sell, such that you can determine whether or not it would be subject to EAR or constitute a violation of EAR for you. So circling back to the beginning of the presentation, I talked about the different aspects of space law, and a lot of the aspects of space law are really exciting. I think the mining, the manned missions, developing law and policy for that, where these issues are going,
are endless. And then we went into some of the regulatory regimes. We talked about the different agencies, ITAR and ITAR. And yes, to a certain extent, this could be viewed as a presentation to sell the need of an attorney to help you work through all these regulations. But it doesn't necessarily need to be me. It's just making sure that we understand the regulations. Now I want to turn to talking about something for the vision of the future. And my thoughts on where we are. Dave introduced me as being an attorney. I've had my law firm here in Chicago for 16 years. I'm a Chicago native of the suburbs. And my wife and I moved back in 2001. And to be honest with you, I didn't expect that I'd have my own law firm. I moved back expecting to start with another medium, large-sized firm. But fortune befell that out of necessity, I started my law firm to have something on the resume while I was looking for other work, and one thing led to another. And so over the 16 years, I've developed a firm to be representing individuals, startups, businesses throughout the world, throughout the United States. I've been in courts throughout the United States, and the focus of our practice has always been technology, the internet. I've always been involved in the internet. We do a lot of aspects of that, intellectual property. So over the last few years, my interest in space and anything space grew to even last spring at about this time, I took an graduate astrophysics class at the University of Chicago. And it was a struggle being a liberal arts major, but I made it through. I got a B-, and one of my colleagues said, well, you know what a B- is in graduate school? And I said, yes, I went to graduate school, but you don't need to ruin it for me. I'm a liberal arts major that just took a graduate astrophysics class. But the reason that I did that, the reason that I piqued my interest in the developments in not only astrophysics and astronomy and the developments that are occurring there every day. I mean, it seems, we're learning about exoplanets, the gravitational waves. It's an amazing time to be alive, and the nuances of discovering the gravitational waves, like they turned it on that day as a test, and overnight they got the signals. Here also with SpaceX, Blue Origin, other companies that are building up the commercial space industry and really propelling the United States more so than the government at this time, more so than NASA. And that may be a good thing, it may be not so good, but it's an opportunity to push all kinds of businesses into the future. We don't need to be the SpaceX, we don't need to be Blue Origin. It's a time for startups, CubeSats, any kind of technology that's going to be used in the commercial space industry. I'm just fascinated by it. And that's one of the reasons why I'm fascinated with what's behind this wall in MHub. And when you think about that, and you think about manufacturing, what other place in the United States has such a solid, really long-standing manufacturing background other than Chicago? And so it's a perfect opportunity for my firm to be involved in the space industry in the sense of providing space law representation. And that's why my interest came. Dave, I think, read an article in the Chicago Tribune, saw my name mentioned, we came together. I've learned about New Space Chicago, and I think that this is the opportunity for startups, for young businesses to really get a foothold in helping to develop the next commercial space. Because you look online, you read the books, I mean, space law has been around for many decades. The commercial space industry has been around for many decades because the government wasn't building all of the rockets. Boeing, other companies were doing that. But in terms of what the real commercial space industry today is and the opportunities, I'm just happy to be able to be in the midst of it. And I think it's an exciting time for lawyers. I think it's an exciting time for businesses. And I think it's an exciting time for anybody that's just interested in space. As I said, whether it's astronomy and astrophysics, or building CubeSats and setting them up, Going to the Adler or doing any kind of technology now, I'm just happy to be a part of it. And that's my information. I'm happy to take any questions and talk about anything. You gotta have some questions. And hopefully I'll have answers to your questions.
I remember in the IT industry back in the mid-90s, there was a lot of, early 90s, there was a lot of talk around encryption. And encryption and key links beyond a certain amount being on ITAR, being subject to ITAR. Then, for some reason, I haven't heard really much of anything about it. I'm just wondering what's happening in terms of encryption software, open source, things like that.
Right. Well, that's a very good question. And ITAR and here both include still provisions relating to or applying to encryption technology. And I don't know the specific level of encryption that would be subject to that, but I think that it's a good question. I would imagine that they'd circle back even more so now with the hack and the significance of data security issues and breaches at the moment. Dave, do you have a comment on that?
In a previous life, I was actually in the network security industry, and yes, encryption was a huge issue with ITAR in the 90s, and then I don't know if it was actually removed from ITAR, but it became much, much less of an issue. And one of the reasons is because the technology was available on the internet, and so it was very easy to export.
Right.
And it also was obvious that it was very important for commerce over the internet, and so the regulations changed. I don't know the specifics of it now, but yeah, that definitely changed at that time. But this actually brings me to my question, which is that so like encryption, which plenty of that is available on the internet, and so you can get to it from anywhere in the world. So that constitutes export, I suppose. A lot of the technologies that we're talking about now for CubeSats are in fact available off the shelf. And so, how does that apply, how does ITAR or your apply to things like that, which are effectively available anywhere?
Right. That's a really good question. And as you're mentioned, I mean, if the information is publicly available, then there's less of an application of the regulations and controlling that in needing a license for it. It kind of has parallels to a certain extent, I guess, to the intellectual property issues, and that is that a lot of the technology or a lot of your intellectual property is public, and if the information is already public, then the control of that is, less of an issue. But that's a good question that as far as ITAR is concerned, I think it's still an area where you need to be careful and obtain confirmation that you would need to have a license for that particular information. But the public nature of it does make it less subject to this regulations.
So, great presentation, thank you. So a follow-up question related to open source. And I hadn't looked at the licenses that a lot of the stuff that people are using in CubeSats specifically are using.
Right.
But a common issue in open source is use of viral licenses versus non-viral licenses. If you're working on an open source project, say for CubeSats, there's a few other ones for like ground segment satellite communications and stuff. If you're working on that and could you wind up with a situation where you're sort of in conflict between a viral license, which hasn't been adjudicated yet, and an ITAR? Are there similar things that happen in other domains that could inform it?
That's a really good question, and I'm going to have to get your business card, and I'll follow up with that. But I think that one of the things in asking these questions is to, even if the answer is a no, getting an answer from somebody that's telling you the answer is no is the way to approach things, and not necessarily presume that. Because if you have, let's say, an advisory opinion or a letter from an attorney or from the agency, if you're able to get that it does not need a license, or the technology, the open source is not, that it's not applicable, then at least you have that reliance. And then going back to the mens rea or the mental state requirements for situations where the regulations prohibit the knowledge or the knowing or intentional violation, if you have an opinion on a question like that that says that this should not be a violation, then that's what you're relying on. And so I think that those are, your question and the other questions are really spot on in terms of where is the distinction between open source, different aspects of those licenses, publicly available information, and like PGP technology and encryption and so forth. Does that still remain subject to the regulations? And I will follow up with that information. I'll find the answer out. It's one of the skills of being a good attorney in my mind, is knowing, I tell my law students and my employees too, is don't believe that you need to have the answer to every question when somebody calls. You can tell a client or you can tell a prospect that that's a very good question and I'll need to get back to you. The skill of a good attorney in my mind is not so much having everything in your mind, but being able to know where to find the answer and provide it. Any other questions? Yes.
These guys are going to have to move on or something here, because I think we do have a couple other questions. So one of the things that characterizes startups often is the startup pivot, right? They think they're working on this, and then a year later they're doing this. And that, of course, creates challenges with any startup in terms of managing their IP portfolio, and lots of startups don't do a good job of that, and then find problems later with prior art against themselves. But, so what would be the idiosyncrasies there for ITAR-related stuff? Like, how early and how closely does a startup, which may be very lean, need to be like watching their sort of ITAR implications as they go through these pivots and trying to figure out what they want to be when they grow up? Like, how to manage that?
Yeah, I think that the answer to that question is, understanding that, the question on whether ITAR or EAR are relevant begins, I think, with a question of what is the technology, not necessarily the application of the technology. Do you follow me? So that I can understand what the question, for a startup, that they might be going in one direction in terms of what they're wanting to do with the technology, and then that's not going well, and then they pivot to do something else. For example, I have a client right now that started with a B2C interface and was really targeting consumers, but the business has turned around to where it's completely B2B interfacing. The business clients may bring in consumers to its portal, but their interface, their only customers are now businesses. But it's the same technology that they're using, it's just a different direction and application of it. And so the way that I would answer your question, or I am answering your question in this way, is that I think that if the technology in the beginning, if a company starts working with technology and that technology falls within the categories, they need to go through the analysis of, again, if they are dealing with exporting and importing of the technology. If you're not exporting or importing the technology, then you're really not needing to, the regulations don't necessarily apply because it's controlling the export and import. But if that is a possibility, and in this area, like it's advising my clients on GDPR,
my clients, I would contend, should be looking at GDPR because every business, nearly every business, has the potential to do business with EU customers. And if you have the potential to do business with EU customers and are acquiring data from European consumers, then GDPR may very well apply, or you may get into issues. Same thing is that if there's even the possibility that you might need to export your technology or work with somebody, a company outside the United States, the question is, does the technology that you're working with fall within the scope of ITAR here? And if it does, then that's where the analysis should begin. And then if you later pivot to a different direction, you're using the same technology, but you're going in a different direction. The technology hasn't changed. That being said, if you start off, if a company says that they're not focused on the technology, but they want to go in one direction in terms of what the business model is, then maybe later. But I think that the first question is, what is the business doing? And what's the technology that it's working with? And if that technology falls within the regulations, then the question is whether or not you need a license to engage in that. And it's not that the transfer of this technology is prohibited. It's prohibited in certain circumstances without a license to transfer that technology. And so that's when you apply for the license. I don't know if I've answered your question.
What it sounds like is that the trigger would be if your technology, basically first check the technology, does it trigger, is it subject to ITAR? No.
If you get into a different technology, then okay, maybe you got to check it again. Or if your business, maybe if you pivot to offer a service that might trigger ITAR, then basically keep an eye on it every time you pivot. It sounds like as long as you didn't change your fundamental technology, your old answer is still good. Either in or out in terms of ITAR. It's the technology that determines.
Yes, I would say start with the technology. But something that just popped into my mind is, when is a good time to be thinking about that? Is it's probably before this, but it would coincide. Like patents. I mean, once you file a patent, it's public. I mean, anybody from anywhere in the world can access and search the patent office records. They're online, and so it's publicly available for anyone. And there are exceptions where you can file certain intellectual property applications under seal, but generally speaking, they're publicly available. And if the prior art is available publicly for more than a year, then you can't file the patent anyway. And so I think that kind of conversation, the intellectual property conversation, because it goes, you started the question with, how startups don't necessarily manage their IP portfolio that well. And I think that conversation should be at the beginning as well, because as soon as a company starts to develop technology or ideas, they should be talking with an IP attorney and having a strategy for protecting that intellectual property. Whether it stays trade secrets or whether we're going to apply for a patent, a lot of times it is the company's startups. The value ends up being in the patent portfolio that you create rather than the actual business model. So I think that the kind of question, and it's a really good question, I would say that it's at the start. Once you start building out the technology or involved in a technology space, at least be aware of the regulations. Yes, Dave.
I'm sure Eric and I can dominate all the Q&A, so please, if any of the rest of you have questions, don't hesitate to step up. But let me follow on with what Eric was asking, which is that with some specifics. So, for example, there are actually the majority of companies that provide CubeSat components are European. And so we're talking about an import situation. And based on what you said earlier, it seems like ITAR might apply to that as well. Is that the case? And so then, since those companies are selling in the U.S., as a customer, is that something that I would have to worry about, or would those there are U.S. representatives that have already dealt with the licensing issues, or how do we deal with that situation, since there are certainly plenty of universities and other people who are buying CubeSat components from these companies and building CubeSats and so forth?
You know, that's a really good question, and so are you buying directly then from the European suppliers?
Probably from their U.S. representative.
From their U.S. representative?
Which may be the company, or it might be a U.S. subsidiary. I don't know. That's part of the issue.
Yeah, so then what I would recommend in that situation is inquiring of the U.S. company for the representative here in the U.S. that you're buying the parts for, and asking them whether they perceive there to be, whether they have an ITAR license, whether they have an ITAR license, whether they need that or they perceive the need for that. And if they say no, then asking them what is their reasoning on that. And I think from a due diligence perspective, then that arguably provides you as the company buying from them some due diligence protection. At the same time, you know, it is going back to the slide where it's knowing the customers and knowing your partners and working with it. It is having those conversations. They may have the license, or they may have determined that they don't need to, that there is no issue with selling it here in the United States. On the other hand, though, and it's an interesting, nuanced aspect, but if you're buying in the United States from somebody in the United States, then you would not necessarily, your company would not be doing anything that would be violating ITAR because you're buying from the entity here in the United States. If you were buying directly from a source outside the United States, then it'd be different. But because you're buying from an entity, whether it's a subsidiary or the representative or somebody here in the United States, then that transaction is domestic and not an international transaction. Now, what their relationship is and what their determination has been from the import of that product and how they're doing it, that's another question. Did I address what you were looking for?
Yeah. Yes.
I'm happy to take any questions later or hang around a little bit. You know, it is a new area, and I realize that I've been able to try to answer the questions as best I can, but it is a developing area, and ITAR is a morass as well as year of regulations, but that's kind of what I enjoy diving into it. So I really appreciate the opportunity to speak to you here today on space law and the future of the commercial space industry in Chicago. And again, I want to thank Dave and New Space and ImHub for hosting the event. Thank you.
Great. Okay, thank you, Charles. Really appreciate it. It's very, very informative, and I certainly have a lot more questions, but maybe for another time. Again, thank you all for coming out. I appreciate your support of New Space Chicago. There's still some beer in the fridge, so you're welcome to hang out. We have the space until 9 o'clock. Please continue the conversation. Our purpose here is to make connections and network with folks who want to build companies in the commercial space industry. So that's what we're all about. Our next event will be in April, and I should be able to tell you what the date is, but I can't remember. But it will be the second Thursday in April. So I hope to see you all then. Thank you very much.
Now it sounds like a party. Yeah, I'll show you around the other side of the wall and talk. Yeah.
Well, so the, I don't remember when I was at, I used to work for the investment there were more and more credible out. So we had different teams saying, yeah, we were